can go ahead and get started. And as people are coming in, I can put in the chat any information that they might need to know. But thank you everybody for taking the time to join us this evening. As far as y'all know, we do have the Wills and Trust class going on tonight. If anybody has any questions, feel free to type them into the chat. A few house rules before we begin. If everybody just wants to mute their mic, that way there's no interruptions and everybody can hear Frank clearly, that would be great. If you also just want to turn off your video as well, that way no one's distracted, that would be amazing as well. And once again, feel free to ask any questions in the chat, and Frank or myself will go ahead and ask those or answer those questions for you. So here is our Wills and Trust class. For those of you that do not know me, my name is Shanice Burgos and I'm with Zine Credit Union. I am the marketing specialist and also one of the financial counselors. So if you have any questions in regards to education or marketing, feel free to reach out at any time. And without further ado, I'm going to go ahead and present Frank Danzo, who is going to be talking about Wills and Trust. So I'm going to stop sharing my screen. And Frank, whenever you are ready, you can take it away.
All right. Thanks, Denise.
Yeah.
So as she mentioned, my name is Frank Danzo. I'm an elder law and estate planning attorney, and this is actually my 29th year doing this, believe it or not. When we talk about wills and trusts and estate planning and elder law, generally we're talking about trying to minimize the damage, minimize the hassle, and minimize the problems when something goes wrong, usually in the areas of death or incapacity or disability. So it's never anybody's favorite topic, but it is something that we all face at one time or another. And as with most things in life, it usually goes better if we do a little bit of planning. And so tonight, we're going to look at some of the issues we face in this area. We're going to look at some of the tools we use to deal with those. And then we'll touch on a couple of the hot topics that I run into in this area if we have time, okay? I usually leave about 5 or 10 minutes at the end to do any questions for anything that I missed covering that you came to see, or anything that we go pretty fast. So if it isn't clear, I'm happy to catch that back up. You also can ask questions while we go along. Just put them in the chat box. I will do my best to answer them as we go if I can, okay? And if not, we can certainly catch them at the end. All right, so the first thing I always like to ask is, everybody talks about, oh, what are the different things? What's the best estate plan you can have, and how do you do stuff? But can somebody tell me, what do you think? What's the best estate plan you can have? What do you think? By the way, I ask a fair amount of questions, so feel free to pop answers in the chat box. When we used to do these live, I like having a little bit of back and forth, so you guys can ask questions and I will too. Anybody have a guess? A trust. Okay. So trust is an excellent tool, and that's one of the things we're going to touch on pretty extensively in the class tonight. A lot of people say a will, some people say power of attorney, and those are all good tools. Somebody once told me the best estate plan you can have is when the last check you write before you die bounces. Now, it sounds kind of cute, but there's a lot of little problems with that plan, and there's one big problem, right? The big problem is we don't know when to write the check, because we don't know when we're going to pass away, right? If you run out of money, write the check too soon, you're going to run out of money while you're alive, and you're going to have to keep living with no money. And as they talk about in some of the other classes,
Oh, Frank, I think you're muted. Sorry.
ooh, okay.
Sorry.
Did I just go mute, or was I mute the whole time?
No. You just went mute about a minute or less, like 30 seconds ago.
Okay. So as I was saying, so one of the things we try to do is use our common tools, wills, trust, powers of attorney, to try to create a plan to minimize the hassle, minimize the damage, and minimize the cost when something goes wrong, okay? Since we can't write the last check before you die and have it bounce. So let's touch on the 3 main problems that we face in this area, okay? They are estate taxes, probate, and incapacity or disability. I'm going to touch on the estate taxes first. Yeah, I don't know how the muting happened, but anyway, we're back. I'm going to touch on the estate taxes first. because it's going to be kind of a short topic here. So who can tell me how much are you allowed to leave right now today in the state of Colorado without paying estate tax? Who has a guess? Anybody? It's more than you think, I can tell you that. 17,250. It is more than that. 17,000 is the annual gifting exclusion. The current limit is 12.9 million. How many people are over 12.9 million? I do not expect to see a lot of hands here, okay? I would have to be zooming with about 10,000 people on average to have one person raise their hand on this, because 99.99% of us are below that limit. That is the federal law. That's the federal estate tax, 12.9 million. So that is nationwide. Colorado currently has no estate tax. Ours expired about 10 years ago, and we have not enacted a new one because of Tabor, our constitutional amendment that says no new tax on the people without a vote of the people. So right now in the state of Colorado, the vast majority of us are below that limit. So why do I bring it up? Well, in the 29 years that I've been practicing, they have changed the law 21 times, and it's been as low as $1 million exemption as recently as about 8 years ago. They have tried to change it back to $1 million exemption 3 times in the last 3 years since President Biden came into office, and they have failed, but they have tried. Okay, so it could happen potentially at any time. If you do go over the limit, it's a 55% tax on everything over the exemption amount. So it's one of the most stiff taxes we face out there, and it could be something that's in your future, depending upon what they do. That includes life insurance and everything you own. So it's not that hard to hit $1 million these days, especially with inflation. So it is an important tax. Keep an eye on it. It'll be national news. You'll hear about it on TV if they're changing it, but be aware it's out there. For 20 of the 29 years I've been practicing, it's been a big deal. Just in the last few years, the limit's gone up quite a bit, and we haven't had to worry about it as much. I still do some planning with that, but not nearly as much given how few people are over the limit, okay? Second problem, much more common, and that's probate. Everybody hates probate. How do I get around probate? How do I avoid probate? But probate is one of the most misunderstood terms out there. What is probate, actually? Well, let me tell you. Probate is the process of getting whatever's in your name when you pass away out of your name and getting it wherever it's supposed to go. It takes place in the county court in the county where you live when you pass away. If you have a will, we submit your will to the probate judge in the probate court. The judge looks it over, makes sure it's valid. If it is, they issue an order appointing your executor, or in Colorado, we call that personal representative, who's then in charge of going out, gathering up all your stuff, paying off your debts, and distributing whatever's left according to your will. If you don't have a will, we follow the state statute. It's about 400 pages. It's called the Colorado Probate Code. And we distribute things and appoint people according to that. It's kind of a one-size-fits-all. The one thing I say about that is it's a one-size-fits-all that doesn't really fit anybody, as you can imagine. When you go to buy clothes and this is one size fits all, and it doesn't really fit anybody very well, right? That's kind of how the statute is. So that's what probate is. It's been around for about 250 years in this country. It's been around for about 800 years overall since we came from the English system of laws, and they've had it since 1244 AD. Okay, so it is not a tax. It is not a trap. It's not the government trying to get you. It's just a government bureaucratic process. It was designed for the main reason of making sure your stuff gets where it's supposed to go. And so everybody thinks, oh, it's making sure my family gets what they're supposed to get. And that is what's supposed to happen. Why do you think the government wants it that way, though? Is it because they really, really care about your family? No. What do they really, really care about? They really care about when they knock on the door and say, hey, we're here to collect the taxes, that somebody answers the door and they have the authority to pay the taxes, right? So what happened 800 years ago is they didn't want We knock on the door. Yeah, the owner's dead. We don't know who's here to pay the tax. We can't pay the taxes. We don't know who's in charge. They don't want that. What they want is all those assets in circulation, keeping the economy moving, and they want to be able to collect their taxes. That's what they really want. So yeah, it does help your family, but that's why the government's concerned about it. So they want to make sure there's an orderly process to make sure it gets transitioned however it's supposed to. Okay. Now, in theory, that sounds like a good process. What's the problem with it? Well, even though in Colorado we have what's called simplified probate, which means you probably won't find an easier or cheaper probate anywhere else in the country. On average, I do it 50 times a year, and it takes about 9 to 18 months, and it runs about $12,000 to $15,000 right now for a pretty basic garden variety probate. If anybody argues over who's in charge or how things are supposed to go, then it goes up from there. And we're pretty reasonable. I would say we're middle of the pack. There are downtown firms charging 50, 100 grand for the same stuff. So it can be a real problem. Okay. I know New York and California are routinely $100,000 or more. So it's much worse on the coast, but it's still a big deal, in my opinion, here in Colorado, because every $15,000 adds up. It's just less left over to go to your family. Okay. So a lot of people want to know how to avoid probate, and we will certainly touch on some ways to do that, because it is the baseline process, but it's also kind of an antiquated process. A lot of bureaucracy, a lot of paperwork, and it is not the only way to do things. Okay. The third problem, though, is one I want to spend a little bit more time on, and that's incapacity or disability. How many people have known somebody who was legally incapacitated, or you yourself have been legally incapacitated according to the laws of the state of Colorado? Okay, I can't see everybody's hands, but I saw one hand go up and I didn't see any other hands. I should see every hand on the screen, and everybody should be buzzing in. Why? Was anybody in here born 18 years old? No. Okay, if we're under the age of 18, what do we call that? We call that being a minor, right? That's one type of legal incapacity. You are not allowed to own property. You are not allowed to make your own decisions, like signing contracts. Who does that for you? Your parents, right? Who are your legal guardians. As we get older, they're doing a better job of keeping us alive longer, but not always in tip-top shape. If you have a stroke, heart attack, develop Alzheimer's, dementia, fall off a ladder and hit your head, car accident, you may end up legally incapacitated to where you can't take care of yourself and you can't manage your assets. If you don't have a plan in place, the default is we go back to the same probate court where we go to probate your will, and we go for guardianship and conservatorship. Guardian takes care of the person, conservator takes care of their assets. The reason you haven't heard about the term conservator as much is because traditionally, most guardianships were for kids. Most kids didn't have very many assets. And so we didn't have a lot of conservatorships. When I started 29 years ago, we did maybe one a year. Now my partner does about 60 or 70 contested guardianship conservatorships every year. He doesn't even do the uncontested ones anymore. There's still plenty of those as well, where it's very easy to tell who's supposed to be doing it and what's supposed to be happening. He's only doing contested. Okay. I still do a few uncontested ones. We have other people doing them. There are now one a week instead of one a year. So it's up 50x from what it was 25 years ago. That's how many more people are becoming incapacitated, and they have money this time because it's not kids anymore. It's adults, right? And so they've got all their stuff and it has to be managed. I don't know if any of you saw that Netflix movie about the people out in Las Vegas. I'm forgetting the name of the title right now, but I'm sure some of you have seen it. And there was a whole racket about the guardianship conservatorships and all the people appointed by the courts and how they targeted people and made money off them. It's a terrible deal. Okay. It costs about the same as probate in Colorado, 15, 20 grand for a basic, if nobody's arguing, but then it goes up from there. And there's guardianship and conservatorship. So you start at 30 or 40,000 and then it goes up from there. Okay. And routinely hundreds of thousands of dollars. Terrible deal. And you're all saying, okay, well, that sounds terrible, but that's not going to happen to me. That's going to happen to people in the next class, right? What is the chance that an adult in the United States is going to become legally incapacitated at some point? What do you think? What percent chance? Who's got a guess? 60. Okay, that's not bad. 20 is a little low, Don. So Benita, 60 is pretty close. Greg is almost right on. It's depending upon who you talk to, 45 to 55% chance. So if you go right in the middle, 50%, 1 in 2, flip a coin. That's what we're talking about. You or the person next to you. Let's put that in perspective for a second. I always talk about this for almost 20 years. It's fun today. Who plays the Powerball? Anybody play the Powerball? I think the jackpot's 1.75 million or billion tonight. Tonight, I think, right? 1.75 billion. The drawing's coming up. That's a lot of money, right? I usually only play when it goes over a billion. We actually haven't gotten around to doing ours yet, but luckily nobody's won the last 3 or 4 drawings. So what are the odds of winning the Powerball? I can tell you 1 in 293 million. That is almost, put everybody in the United States name in a hat, draw one name, and that's your chances of winning. Okay. You have a better chance of being struck by lightning twice than winning the Powerball. You have a better chance of being struck by lightning while you're being eaten by a shark than winning the Powerball. Every year they come out with those, oh, there's a shark attack in North Carolina or Florida or California or Hawaii, right? And they say, don't worry about it. Don't worry about it. It's 1 in 255 million that you're going to be attacked by a shark. I think those are up a little bit, by the way, because I keep hearing more and more about them. I'm not sure what's going on with the sharks. But regardless, the odds are really bad. And you have a better chance of being struck by lightning twice. And yet they say lightning never strikes twice, right? But you say, oh, 1.75 billion, prizes equal 50% of sales. That means you got to sell 3.5 billion tickets to get that jackpot. That's like 12 tickets for every person in the United States where you have to be struck by lightning while you're being eaten by a shark in order to win, but everybody's playing the Powerball. So if it's flip a coin chance that you're going to become incapacitated, I'm assuming everybody's got 2 or 3 backup plans for that, right? Nope. What percent of people are planning for incapacity or disability? Well, depending upon who you talk to, we know 70% of people do no planning at all. Of the 30% that do, less than half are planning for incapacity. So somewhere around 10 to 12%. That's a real problem, right? If 88% of the people are not planning for this, now you know why my partner is so busy, because everybody's having it and everybody's fighting about it and nobody's planned for it. So they're all going to court. That's the problem. I only have 30% of the people to work with to begin with. So we're going to try to close that gap a little bit tonight by teaching you guys about some of this stuff and what you can do about it, okay? To me, that's one of the biggest problems we face. What happens to me if I'm still here? Wait a minute. Everybody worries about probate. Everybody worries about estate taxes. Everybody worries, are my kids going to get my stuff? And those are all important, but guess what? You're not going to be here for any of those things. You are going to be here for guardianship, conservatorship if you become incapacitated, okay? So to me, that should be pretty high up on the list. What happens to me if I'm still here? So we'll try to close that down a little bit tonight. So there's 3 main tools we use in this area. They are wills, powers of attorney, and trusts. How many people have a will? Okay, I see one hand. Again, that's probably the most common planning tool that I see. There's 2. Okay, if you've done any planning, most likely you have a will. It's the oldest one in this country by far. We've had them for 250 years, okay? What does your will do for you? Well, let me tell you, if it's validly executed, there's 2 main things it's going to do. Number 1, it's going to say who's in charge, who's the executor. As I mentioned, Colorado, we call it personal representative. Okay, who's in charge of doing all this? Who's going to be appointed by the court and have the authority to go deal with all your stuff? That's your personal representative. Number 2, who are the beneficiaries and what do they get? Okay, whether it's the devisees, whether it's direct beneficiary, whatever it might be, whether we're putting stuff into some kind of holding forum, a trust, or whatever it might be, who gets what? Okay, who are they and what do they get? If you have minor children, it will say who's going to be the guardian for them. 95% of people with minor children do not do the appropriate planning, so we don't see a lot of those. It also doesn't come into play that much, so it's not a huge thing. But those are the main things that your will does for you, okay? How many wills can you have during your lifetime? As many as you want, right? You can keep doing them all day, every day. Which one are we going to look at? The last one that you write, okay? It usually says I revoke all prior wills, and this becomes my new will, okay? So we're going to look at the last one. That's the one we know you can't change anymore because you're not here. When does your will take effect? Your will takes effect when you die, because that's part of it. We know you can't change anymore, okay? It does not take effect before that. It has no effect. It does not do anything. In fact, about 10 years ago, the courts stopped taking your will. So it used to be you could do your will, you could send it into the court and say, okay, here it is. It's ready to go whenever we need it. And about 10 years ago, they stopped doing that and allowing those. Why? Now they will only take your will if it comes with your death certificate. That's the only time they will accept them. Otherwise, they send them back to you. Why? Because all the major metro counties had these giant warehouses with tens of thousands of old wills that by law they were not allowed to get rid of. And half the people had moved to Florida and passed away down there and never reclaimed their will, or redone it 6 times and whatever. And they were never coming back to claim them. So now they don't do that anymore because they couldn't afford to store them. So they went through this whole procedure and we had to make a big statutory adjustment. And now they only take your will if it comes with your death certificate, okay? But your will only takes effect when you pass away, which means by definition, it cannot help you while you're alive. That means we need a different tool while we're alive. And that's our second tool. It's called a power of attorney, okay? Power of attorney is a document where you give someone the power to act on your behalf. They become your agent, okay? It's very similar to a sports agent or a real estate agent or a Hollywood agent, whatever you want to call those, where they do stuff on your behalf and you authorize them to do certain things. Now, you can have a general power of attorney that says you can do anything I can do, okay? By the way, you can only do legal things with the power of attorney. So you cannot go rob a bank and then when the police show up, say, oh, go arrest that person over there because I was doing this as their agent under power of attorney. No, it doesn't work that way. You can only do legal things with a power of attorney. But a general power, there's a lot of legal things you can do. So it's a very broad power. Or you can have a specific power of attorney, and that gives someone the specific right to do a certain thing. The most common example of that, if you've got the closing on your house and you're going to be away for some reason or out of town for some reason, but you really want the closing to go through, especially in this market, because things are kind of cooling down a little bit. We don't want to miss those closings. Then you could give someone a specific real estate power of attorney that says you can sign my name this one time on this one day for this one property, and that's it. And if it doesn't happen, it doesn't happen, but whatever, that's your power. And then it goes away, okay? So that could be the best example of a specific power of attorney. In my area, we usually have 2 powers of attorney. We have a medical power of attorney, who's in charge and what do we do to take care of you, and a financial power of attorney, who's in charge and what do we do to take care of all your stuff, okay? So those are the most common ones that I use every day to the tune of about 7,000 times or so over the last 29 years. But powers of attorney also fall into 2 other categories. There are immediate powers of attorney. As soon as you sign it, your agent has the power. They can act immediately. Or there are springing powers of attorney that spring into effect or come into effect upon some condition, like when I become incapacitated. So it'll say this power of attorney is only effective upon the incapacity of the person. That's the most likely language you'll see. How many people think immediate power of attorney is the way to go? Nobody. How many people think springing power of attorney is the way to go? 1, 2, 3. Okay. Nobody ever thinks, there's a raised hand. All right. Nobody ever thinks immediate's the way to go. Let me ask you a question. In my career, I've done about 7,000 powers of attorney, only 2 springing powers. And in both of those, I put a bunch of stuff in the file, said I don't recommend doing it this way. Why do you think that is? What happens when you walk into the bank and you hand them a springing power of attorney? and they look at it and go, this power of attorney is only effective upon the incapacity of the person. What does the bank say? We need proof, right? We need proof that the person's incapacitated or this has no effect. How do you prove incapacity in the state of Colorado? I'll give you a hint. We already talked about it. It's called guardianship and conservatorship. That is the procedure legally to determine that somebody's incapacitated. So when springing powers of attorney came out about 20 years ago, they were the kind of the hot new thing right out of the textbook. The problem is, as a practical matter, they don't work very well. Okay. It's quite a procedure. Guardianship, conservatorship takes about 3 to 6 months, costs $30,000 or $40,000. Okay. So having that procedure necessary to activate your power of attorney, the whole point of the power of attorney is to avoid guardianship, conservatorship. So it really doesn't help you if it requires that in order to activate it. Okay. So a lot of times you'll see, oh, you just need 2 licensed physicians to certify in writing, and then the power of attorney springs into effect. Anybody ever try to get 2 licensed physicians to certify in writing that somebody's incapacitated? I can tell you, we do it all the time. It is not as easy as it sounds when you just roll it off your tongue. If you're lucky, you can probably get appointments with the 2 doctors, but your primary physician's going to be like, oh, take 2 aspirin and call me in the morning, right? If you still feel bad, I'll refer you to a specialist. When you go to see a specialist, you got to be a new patient. We got to do the full intake. Where are you? And do all the tests, right? And where are you? Where are you sitting right now? And what's going on? How long does it take to do all that? A new patient intake with all the tests? Half day to a full day, right? Depending upon who you're talking to. How far out on a doctor's calendar do you have to go to get a half day or a full day? Whew, I used to say 6 weeks. I hear now it's closer to 6 months since COVID, right? It's real. 4 to 6 months is now pretty standard. Shoot, I can't get in to see the dentist for a cleaning for 3 months, and that's just for a cleaning. This is not for an evaluation on whether I have capacity or not. So when you got to get into the neurologist, oh my goodness, guess what? With the number of people and the number of people getting incapacitated and the number of people in nursing homes and memory care facilities, you think neurologists aren't busy? Oh my goodness, they are really, really busy. Okay. So you got to get appointments with 2 doctors. You got to get them to diagnose you, which means you better not have a good day on the day you go to the doctor, right? Oh my goodness, the number of people who come in, they don't know who I am. They don't know where they are. But for some reason, they go in on the morning of the test and they had a good morning. And so suddenly they pass the test. You got to reschedule 6 more weeks or 6 more months or whatever it's going to take. Okay. You got to get them to agree. There's got to be 2 of them. And then you got to get them to certify in writing that somebody's incapacitated. Guess what? They're liable for that, right? So guess what? Doctors really hate those letters. They don't get any extra money for them and they get liability for them. That's the worst possible thing you can say. Hey, how about have some extra liability and don't get paid for it? Terrible. Extra work, extra time, extra liability, no money. Terrible, terrible situation for them. So they don't like doing them. The point being, if you got an emergency, are you going to have time to run around and do all that stuff I just said? Probably not, right? And so here's the really interesting part. About 10, 12 years ago, they came out with HIPAA. Everybody knows what HIPAA is, right? Federal law, medical privacy, all of that. Only person entitled to get it is you, not your spouse, not your kids, not your friends, not your family, just you. Well, if your agent goes in to activate the medical power of attorney and they say, oh, we need proof, and you go to get the proof from the doctor, but the doctor's bound by HIPAA, they can't give out the information until your agent's authorized to get it, but you can't get the information until it's activated to authorize you to get it. You just go around in this never-ending loop, right? Catch-22. We can't get out of that logic circle because we can't activate it without the information. You can't get the information until it's activated. You can kind of see where I'm going with that, okay? But it's a real problem. Now, here's the really interesting part. Let's say you're like, oh, if you say, I don't want my agent to have the power right now because I'm afraid that they might what? What do you think your agent's going to do if you say, I don't want them to have an immediate power. I want to have them springing power. Why? What are you afraid that they might do? What's your guess? You can say it. You can say it. What do you think someone's going to do if you're afraid to give them immediate power? They might what? Take all your stuff, right? Steal your stuff. Well, wait a minute. If you think your agent could steal all your stuff, should you be giving them power of attorney in the first place? I'm going to argue even that there's a logical flaw. Even past all the mechanics of it, what's the point of a springing power? You either trust somebody or you don't, okay? So what do I recommend? I recommend you pick somebody you trust, you give them an immediate power of attorney, so it's ready to go when the emergency happens, and then you keep it in your possession because they can't run around and do stuff with it unless they actually have it. They got to show it to people in order to do stuff, okay? And that gets you about 98, 99%. Is it possible somebody could do something bad? Yeah, that means you misjudged them or whatever, but they also got to go get it from you while you're still alive. Like, that's a lot of stuff. And realistically, if you're picking somebody who cares about you, who you trust, they probably aren't going to be doing that, okay? If you don't have somebody you trust, power of attorney is not the right tool for you. All right, let me see if I missed a question here. Let's see, there's a couple. Who is they? I don't know what we missed there, but we'll have to come back on that. Be more specific on that and I'll try to answer it. If I'm married, can I have someone other than my spouse act as power of attorney? Yes, you can. Spouses do not have the automatic right for power of attorney. I get into that later. We're all autonomous. You can give, your spouse is not automatically entitled to do anything with you and all your stuff. That's what guardianship and conservatorship is for. And your spouse has to go through that same process unless you give them some other tool like a power of attorney or trust. Okay. We have to have prove it. Yes. They could take advantage of you, take over, take all your stuff, take control of your assets. Yes. How much does a power of attorney cost? It depends. We do most of our planning, and I'll cover this more at the end, on a flat fee basis, and we usually do it as part of a plan. So if you do a single power of attorney by itself, it's probably $300 or $400. Most of them, though, if you end up doing as part of a package, it brings the cost per document down because there's a lot of stuff you have to go through to do something like this. And if you're doing one document or 10, it's the same process either way. And so usually doing more documents brings down the cost per document, depending upon what plan you're doing. Okay, so we'll talk about that more in a bit. But getting back to the powers of attorney, if you don't have somebody you trust, that leads us to our third tool, oddly enough, which is the trust. Okay, and so a trust is actually something where you trust someone to do something, but you actually get to put some rules and guidelines in there as well. And so it's a very powerful instrument or document. Most people think trusts are the hot new thing. Actually, trusts are the hot old thing. Trusts have been around for about 2,000 years. Wills have only been around for about 800 years. Trusts in the United States started to become really popular about 50 years ago, and they have certainly been popular in the 29 years I've been practicing. When I started, you could flip a coin. Some people said trusts, some people said wills. It didn't matter. I would say now, over the last 20 years, trusts have become super popular, super easy to work with, and they are very much on the upswing as far as one of the better tools we can use in this area. Okay. But getting back to the trusts themselves, they've been around for about 2,000 years, and they are not just for the Rockefellers, the Kennedys, the Trumps. Let's see, the most famous trust in the world, Shakespeare did one in the 1600s, still going on today. It's got billions of dollars in it. Probably the most famous trust in the world is the King's Trust in England. That has been around for about 700 years. I think the Magna Carta, or whenever that was, 700 or 800 years ago. It has over $1 trillion in it, including Buckingham Palace, the crown jewels, and all of the other castles and lands and titles and everything else. You are a beneficiary of the trust by virtue of being born into that royal bloodline. That's how you get your stuff. But then it is still held in the trust, and it goes on to the next generation as each new wave of people come along to become the new beneficiaries. Okay? So when we have a trust and a trust for the rest of us, there are three parties to a trust. Okay, so a trust is a private contract. The three parties are the settlor, the trustee, and the beneficiary. Okay, the settlor is the person who sets the rules. They are the only person that can revoke, amend, or change the trust. The trustee is the manager of the trust. They are in charge of doing whatever it says to do in the trust and carrying out the terms. So the settlor is the creator, the trustee is the manager, the beneficiary is the person who gets the benefit of the trust according to the terms. The most popular type of trust is the revocable living trust. It is revocable, meaning you can revoke it, amend it, or change it whenever you want, as long as you're alive and competent. It is a living trust. Oh, sorry, as opposed to irrevocable. Irrevocable means you can't revoke it, amend it, or change it. Okay. And you can't get your stuff back once you put it in. It's irrevocable. 95% of all trusts are revocable because most people don't want to give up control. You would only give up control for some very specific reason, usually having to do with something with the government. Okay. Like I want to qualify for Medicaid, or I want to get some tax benefits, or I want asset protection. Those are the main categories that usually involve irrevocable trusts. But the vast majority of people don't want that. They don't want to give up control. Living trust means you create it while you're alive, which means you can actually benefit from it, as opposed to a testamentary trust that's created out of your last will and testament, which only takes effect, wills take effect only after you die. So by definition, cannot help you while you're alive. So 50 years ago, the most common types of trust you'd see were wills with testamentary trust. You probated the will, you created the testamentary trust, you moved all the assets into the trust. I still do those today, but I really only do them for usually younger families that are in their 20s with little kids. And we're saying we don't really have any assets. We just have a life insurance policy. But if we have a car accident, we got to have this bucket spring up, catch this life insurance, which is going to pay out, and hold it for the little kids till they're old enough. And so that works pretty well for that. For most people who have assets, testamentary trusts are kind of passé. They are old school and they're not the best way to do it. So most people look at revocable living trust as the most popular type of trust today. Probably 90% of all the trusts I do these days are revocable living trusts. Okay. The nice thing about the revocable living trust, it allows you to create a plan to say who's in charge and what do we do to take care of me, take care of my assets if I get sick or if I pass away. So if you think about that for a second, it's an extremely powerful tool because you don't have to give up any control, but we have this huge backup plan that covers a million different scenarios if something goes wrong. And so it is by far the most comprehensive, the most protection, the most efficient, the kindest, gentlest way to make sure we're taken care of, and then make sure everything gets where it's supposed to go without going to court for probate, guardianship, and conservatorship. And so that, to me, is the biggest reason that people choose this kind of thing. Okay. Now, there are also, one of the hot topics that I always see is the asset protection element. If people come to see me to do asset protection, which they do 20 times a year for the last 15 years, it is somewhere between $25,000 and $50,000 to set up an asset protection trust. People do it, but they got to have something to protect, and it's pretty serious. Okay. You have the ability to give your beneficiaries the same levels of asset protection through your own trust planning at basically no additional cost. So when you set up your trust to take care of you and avoid court and do all these things we're talking about, you can also have it continue on for your kids, grandkids, or whoever the beneficiaries are. And that there can be asset protection elements to that trust at no additional charge. Okay. And the reason it costs so much to do it for yourself is because there's a whole bunch of very specific rules. It's very complicated. They're irrevocable, all this stuff. And you can't get access to your stuff. Therefore, creditors can't get access to it as well. So there are reasons people do it, but they got to be real serious about it. It's not a joke. Okay. And so setting one up for yourself, if you could just run out and do it today, and people would do it all the time, there would be no credit. There would be none of that, none of those things, because people wouldn't be able to get the money that's owed to them. And so when you do this for your beneficiaries, it's called a third party doing it. And so when they get it, oh, I don't have it. I'm not in charge of it. They don't give it to me. The trustee's managing it. I'm just a beneficiary. You got to go talk to the trustee. The trustee is going to be instructed. You can't give this money away to creditors, and so there's asset protection elements there. So it's a very powerful planning tool for protecting your family that you can set up yourself. at very little additional cost to what they might do otherwise. And certainly, 1/10 of what it would take to do straight asset protection. So very powerful tool. All right. So you can either create a trust or a will. What's the benefit of either? So generally speaking, when we do planning, we do some kind of plan and we put the different tools together because we're trying to cover a lot of different scenarios. We don't know what's going to happen. Okay. And so you can generally do a will-based plan. You're going to go the traditional route. Wills go through the court system. All right. And we'll add powers of attorney to it. And we'll try to do stuff and you can cobble together a plan that way. It just doesn't cover all the possible scenarios. So one of the reasons people do a trust-based plan, you're still going to have a bunch of supporting documents that go with the trust because the trust doesn't cover every possible thing, but it covers the most out of all the things. And so we'll have backups. They all refer to the trust or they point to the trust and it all goes together because we're trying to cover a million different things that could happen. Okay. So yeah, you can do one either way. Generally, you'll have a will-based plan or a will-centered plan or a trust-centered plan, and then there'll be a package of stuff that goes with it to try to cover all the possible things. All right, let's see here. We got about 5 or 10 minutes before I would open it up for questions. We touched on the asset protection element. That's one of the hottest topics I see. Of course, the reason for that being every time you turn on a TV, open a magazine, look at a billboard or a bus, it says, have you been injured? $2.9 million. That's not the only type of creditor protection. There are divorces. There are business failures, business bankruptcies, medical bankruptcies, crashes in the economy, foreclosures, and all the personal injury stuff. All of those different things these days. There are so many ways to get in trouble. The days of looking somebody in the eye, shaking their hand and saying, we'll make this right. Those are long gone, right? Now it's all litigation and fighting and suing people and all of that stuff. So on the one hand, all the injury stuff is up. On the other hand, that's where the asset protection side comes up. Hey, I spent my whole life trying to save all this stuff. If I have one bad thing, can't we just have the limit be, my insurance or whatever it is? So there's different ways you argue about that. That's one of the hotter topics. Certainly kids running around their 20s and 30s. We've all done stupid stuff. Back in those days, kids still do it today. And now everything is recorded and it's going to be on YouTube in 5 minutes, right? So there's nothing they can get away with. I don't know if I'd want to be a kid these days, the way everything goes, but it is what it is. So that's one of the hot topics. The other hot topic that I see a lot of that also involves asset protection is on the Medicaid side, okay? The long-term care side of things. So we've talked about legal stuff, who's in charge and who makes decisions for me. But how do you pay for all this stuff if you need care, right? So generally speaking, your health insurance covers short-term care or acute care. That is anything under 100 days. So if you get sick, you have an accident, an injury, a medical condition, whatever, they cover short-term care up to about 100 days. Whenever you have recuperated, rehabbed, or stopped getting better for whatever reason, that is now considered long-term care. That is not covered by health insurance. You either have to have long-term care insurance or you got to pay for the care yourself. Okay. If you run out of money, the government has put in Medicaid and the government will pay for you. But, Medicaid, the first thing I always point out is welfare. You got to run out of money in order to qualify. When I started, they were just putting in the stuff. So in like 1985, you could have $1 million back when $1 million was a lot of money, and you could give it away to your kid, have it today, give it away to your kids tomorrow. And the next day go in and apply for Medicaid and say, government, take care of me, pay for me. I don't have any money. Government figured out really quick, this was back when Ronald Reagan was in office, and they figured out a couple things on all this stuff. Number one, they figured out we can't have people giving away $1 million and then saying we got to pay for them. We can't afford to pay for everybody. Okay. So in 1985, they immediately started ratcheting down the rules. The other thing they started doing, of course, had to do with the trusts. In 1984, people were like, oh, we had a 72% marginal income tax bracket. And so people would take their stuff, go set up 10 trusts, spread their income $1 million into 10 trusts, 100,000 each, and drop their bracket from 72 back to like 25 or whatever. And so guess what they did on both these? They shut down the Medicaid part. They also shut down the trust part, saying trusts automatically go to the highest bracket at $10,000 of income. Well, that took care of that real quick because your 10 trusts are getting wiped out faster than you were individually. The point being, they closed these loopholes pretty quick. And for the last 35 years, they had been ratcheting down on the Medicaid rules because the cost keeps going up and the number of people keeps going up. They cannot afford to pay for everybody. So one of the first things we have to sit down and do when we talk about doing planning is talk about, are we doing a traditional estate planning? I've got assets, I'm going to keep them, use them as long as I can, and then pass them on as efficiently as possible. Or are we going to do long-term care Medicaid planning? Oh man, I don't know if I have enough assets. I may run out. They may get wiped out by some kind of illness or whatever. So I want to try to save as much as I can and still qualify for Medicaid. And since they've been ratcheting down the rules for 35 years, that's one of the first things we have to sit down and do. You can't do both. You cannot keep your assets until you die or plan to run out of them before you die and get rid of them. You can't do both. They're opposite directions. So that's one of the first, and this is one of the most hot topics I see because everybody's talking about it. We're all living longer. We're all here. We're all these people, 50% of people are becoming incapacitated. When they are, how are they being taken care of and who's paying for it all? And so that's one of the first things I see. So when we sit down and initially, that's part of our analysis. We got to do planning and then come up with which way are we going and what tools are we going to use and things like that. So we do Medicaid planning in your packets that I think Janice has set up with the downloads, and I think they're going to email them to you after the workshop. There's some stuff about, we write the book on it. I've been writing it for like 14 years now, and how to protect your assets and things like that. That's one of the first things we look at. What type of plan are we doing and where are we going with it? What are the goals? You can't accomplish all the goals of everything, but we try to, hit as many as we can. So keep that in mind as well. All right, so let's see here. A couple questions, and then we're right there at the 6:50. So I'll go ahead and open it up for questions from here on out. Okay. To confirm, if I have a will, this will need to go through probate if I pass away. Yeah. So wills go through probate. Okay. You can take your will and throw it in the trash, or you can put it in a drawer and never pull it out, and it won't have to go through probate. But if you want to use the will has to be probated. That's part of the process. You submit the will to the probate court, the judge makes sure it's valid, and then they issue an order appointing your executor or personal representative. So yes, wills do go through probate. That is the purpose. It is the instructions to the judge in the probate court on what to do. Okay. If you don't have any assets, by the way, you probably don't need a will, and you probably won't go through probate. You don't see probate for all the people downtown, the people experiencing homelessness and all of that. We don't have a lot of probates for those, okay, because they don't have anything that there is to go get. But when we're trying to get stuff out of your name and you've passed away, the only way to do that is to go through probate and do that if it's in your name, and your will is the tool we use to do that. Okay. If I have a trust, I bypass the probate court and funds can become available to the beneficiary in a more timely manner. Yes. So when you have a trust, use this private contract. You pick the same people to be in charge. You give away the same assets to the same beneficiaries, but we use the private contract. We don't go to court to do it all. Okay. So it cuts out about 85, 90%. I would say to administer a trust takes about 90 days, give or take. To administer a will is 12 to 18 months on average. So if you say 15 months, somewhere in the middle, you're cutting out 85, 90% of the time, hassle, and cost when you don't use the will. Okay. I see Janice is putting up the packets and stuff. Okay. Here's a few packets. Will you email that to us? I'm using my phone and can't download. So yes, I think Janice is going to email to everybody who attended PDFs of the stuff. They'll go out in an email after the webinar. Or you can download them from this link here. There's a Google Drive that you can do all that as well. Okay. All right. As part of coming to the class, before I turn you guys loose here, everybody who's come, you're entitled to, you'll see in your packets, you're entitled to sit down with me at no charge for about 30 minutes. And we can go through what the options are. If you have a plan, we can look at what it's doing and if it's still doing it right, and what it might take to update it or tweak it to fix it if it's outdated or there's things that need to be addressed. If you don't have a plan, we can go over what the options are and what they might cost. Okay. Like I said, we do most of our planning by flat fee. Nobody likes to plan by the hour because we could plan forever. We can talk, have meetings, do drafts, revise them, discuss them, answer questions, and go on forever, and do it by the hour. Nobody likes to do that. So we do most of it by a flat fee. We put together the different packages. Once I get a feel for your situation, I can tell you if we can help you, what the options are, and what they might cost. If you don't want to do anything, you don't have to. If you do, you'll know what they are. We give 20% off because you came to the class off our regular fees, which is kind of a nice deal. I've been doing it for, I think, almost 15 years now with Zing, and it used to be Denver Community Credit Union. So we've been doing it for a long time and happy to help with that. Okay. If you don't want to do one, you don't have to. There's no obligation. In the materials, it tells you how to get a hold of me. You can call, you can email, you can go to our website. Any of those are fine. You're welcome. You're welcome. Appreciate it. If I have assets, can I use a trust or do I need a will? So generally speaking, as I was saying before, if you're going to do a trust-based plan, there's going to be supporting documents. You'll probably have what we call a pour-over will, which is a backup to the trust. Anything that fell out of the trust or you didn't have a chance to put it in there, this will catch it and pour it over into the trust for you. Still goes through probate, so that's not ideal, but we have backups there just in case. Or you can do a will-based plan without the trust, and then you're going to roll the dice, or you're going to go through probate. So that's part of what we would sit down and go through. What are the options? What are the pros and cons of doing different ways? And what do you think? I don't do trusts for everybody. Probably only about 60% of the people do I do trusts for. So they're not right for everybody. They're just really popular, and they're popular for a lot of different reasons for a lot of different people. But they're not right for everybody. And if it's not right, we don't do it that way. So it's up to you guys how you want to handle that. Okay. All right. I don't see any other questions in the queue unless anybody has any. If you don't, that's fine. You guys are free to go. You should have your access to your materials and stuff. And if you do have trusts, I will keep on answering here, or questions. Does the trust eliminate the need for probate? So if you put your stuff in the trust, it does not go through probate. So if you leave something out of the trust, that's when it goes through potentially probate. The best examples I can give to you, people routinely will refinance their house and the bank makes them pull it out and they forget to put it back in, or nobody tells them to. That can become a problem. Sometimes they inherit stuff and they don't realize, oh, I inherited this, I got to put this in my trust as well, or they forget, or they don't have a chance. If you won the Powerball and you were so excited, you had a heart attack and died, and you're holding the ticket in your hand, you didn't get it in your trust, right? That's going to be a problem. Luckily for that, it'd be, 1.7 billion, you can handle 20,000 for probate or whatever. It wouldn't be the end of the world. So, I don't know that that'd be the worst problem, but those are all examples of why you might not do it for some reason, if you forgot, or you didn't realize, or you didn't have time, or something like that. Okay. Yeah. All right. Everybody's saying thank you. So I think we're good. All right, guys, I appreciate you doing this. Hopefully it was helpful. It was good to meet you all by Zoom here. You've got access to all your packets and all your stuff. There's an organizing your legal affairs. It's like 30 pages. Goes through a lot of the stuff I talked about and how it all works in detail. So you'll see in there why all the different things and why trusts have become really popular and things like that as well. Okay. All right. Well, I appreciate you coming. Denise, do you want to do any wrap up stuff or anything like that? Or
I don't have anything to say besides thank you so much for giving us an hour of your evening to explain everything to us. I hope everybody found it very useful and insightful. I know I did for myself. But thank you so much again, Frank. If anybody has any questions, you can feel free to email the email that sent out all the information about the webinar. And all the packets will be going out in an email tomorrow. So make sure to keep an eye out for that as well. And don't forget to take advantage of those free complimentary 30 minutes that you can sit down one-on-one with Frank. And once again, thank you everybody for taking the time out of their evening to learn a little bit more. And we'll see y'all next time. Thank you so much.
Sounds good. Thanks, Janice. All right, guys.
Frank.
Have a good
Bye.
week.
You too.